In 1968, almost 50 years ago, CED released its very first study on money in politics and democratic institutions. And we did so back then and continued those programs because we have a fervent belief that a strong and healthy democracy is not just good for the political system, that it's good for the overall economy and good for business. So just recently, 2 weeks ago, we released a study on partisan gerrymandering, and I believe there are copies at your table if you can sift through all the, there we go. And we've asked our friend Jean Card to moderate this panel. Jean is a professional writer. She works closely with CED, and she's a spokeswoman and a public speaking coach who spent 6 years in the executive branch of the US government as a speechwriter for Secretaries of Treasury, Labor, as well as the Attorney General. Jean is going to take it from here, and I think everyone has their the bios of the speakers, so I think you could just introduce by name and affiliation our panelists, and we can get started. Thank you, Jean.
Thank you, Mike. It's great to be here. Can you guys hear me okay? We're gonna start today actually with a presentation from Gerald Hebert. Gerry is the Senior Director of Voting Rights and Redistricting at the Campaign Legal Center. And I do want to let you all know that gerrymandering was not named after Gerry, although you'll start to think it should have been once you find out what a true expert and specialist he is on this issue. We're also going to hear today from Nathan Rosenberg, who's a founding partner of the management consulting firm Insigniam. And that firm pioneered the field of organizational transformation and breakthrough performance. I've also just learned that Nathan is the proud owner of a Rhodesian Ridgeback. And just in a few minutes of speaking to him, I'm not one bit surprised. I'm a dog person, and it all fits together. Jane Sherburne is also with us. She's a principal of Sherburne PLLC, and her firm advises clients in crisis environments and with regulatory policy. I'm sure you all will look at her bio. It's really a spectacular legal resume, but I'm quite curious, especially about her work and affiliations with different boards and committees. She strikes me as, from what I've read, a very cause-oriented professional, which I think is perfect for a panel like this. So without further ado, I would like to kick off with Gerry to give us an overview of our topic today. Thanks, Gerry.
Okay. Thank you. Thank you, Committee on Economic Development and Mike for inviting me today. Talking about one of my favorite topics, gerrymandering, which has been around for a long time, named after the one of the vice presidents of the United States early on, Eldridge Gerry, who pronounced his name with a hard G. It became known as Eldridge Gerry gerrymandering when he approved a new district in Massachusetts that looked like a salamander because it wound around the city of Boston up to the North Shore, and it looked like a salamander, so they combined Gerry with salamander to come up with the term gerrymander in the newspapers back then, and it's been with us ever since. Interestingly enough, it wasn't until the 1960s when the US Supreme Court finally declared that there was an equal population requirement under the Constitution that redistricting really took on as a revolution with the one person, one vote cases, requiring states to redraw their congressional districts, their state legislative and state senate districts. And so throughout the 1960s and 70s, there was a lot of litigation under the equal population doctrine. And it wasn't until 1986 when Democrats challenged a Republican gerrymander in Indiana that a case worked its way finally to the US Supreme Court, where the challenge was that the Republicans drew that map with a partisan intent to disadvantage Democrats. And so the Supreme Court had to decide for the first time ever in 1986 in a case called Davis versus Bandemer whether or not partisan gerrymandering was something called justiciable, meaning you could bring claims in the federal court. Plaintiffs had to show both discriminatory purpose or intent and to show that, which is relatively easy because partisans who draw maps, whether they're Democrats or Republicans, are pretty clear about what their intent is, which is to advantage their party and disadvantage the other, and whether to show that it's a discriminatory effect. So what happened after 1986 is that nothing happened, that no case ever was brought until 2004, when the Supreme Court revisited the issue again. And even though in 1986 it said these claims are justiciable, you can actually bring partisan gerrymandering claims in the courts, nobody ever was able to justice it. It just didn't get adjudicated in the Supreme Court at all. In the early 2000s, we brought a case I was involved with in Pennsylvania called Veith versus Jubilarer, where we brought a partisan gerrymandering case challenging the Pennsylvania congressional redistricting. And in the case, we got 4.5 votes out of 9. You think, well, that's kind of strange. Out of the Supreme Court's 9 justices, 4 of the justices said, we would overrule Davis versus Bandemer, and we don't even want these cases in the federal courts because they're essentially political questions. 4 justices said, not only do we think these are justiciable questions, we have some tests to measure how partisan a plan must be for it to be unconstitutional. We actually have a standard that we think we can impose. And then there was the 9th justice, Justice Kennedy, who said, who's still on the court, who said, well, I don't agree with you 4 who say you can't bring the cases anymore, but I also don't like you 4 standards that you've come up with, so I'm going to vote with the people who said it's not unconstitutional, this map, because I don't know what the standard is, but I'm not willing to go so far as to say you can't bring these cases in the courts. And then he proceeded to lay out a theory under, get this, the First Amendment for whether or not partisan gerrymandering cases should be brought. And the First Amendment, of course, deals with freedom of speech and freedom of association, so presumably political parties could try to put their partisan gerrymandering claims in that box. Well, unfortunately, nobody was able to do so following Veith versus Jubilarer. Throughout the decade, people tried. They brought First Amendment claims. League of Women Voters did. The Republicans did. The Democrats did. Nobody could get a case to win and get it up to the Supreme Court. So along comes the 2010 redistricting cycle, and we felt that we took, there's a picture, by the way, of Eldridge Gary's Gerrymander right there, which goes around the city of Boston, and that was actually out of the Boston newspapers in the early 1800s. So we felt, well, we need a test. Obviously, Justice Kennedy is looking for a test. He says these claims are justiciable. So how do we identify a gerrymander? So the first thing you should understand is that all gerrymanders rely on only 2 techniques to achieve partisan advantage, either packing or cracking. Packing and cracking, and I'm going to give you a hypothetical here. So let's assume we have 50 precincts, 40% of them are teal and 60% of them are blue. So if you really want to use packing and cracking, you can actually draw districts in which the teal group, which is only 40% of the population, can actually win 60% of the seats by gerrymandering. And how do they do that? Well, they do that by packing and cracking. So here's an example of that plan packed. You can see that districts 4 and 5 on the bottom have mostly the blue all packed into one district with what a little sliver of teal, whereas the teal ones have a majority in 1, 2, and 3, so they're able to win that as a result of the packing and cracking. Now, if you want to see districts that look cracked, you could see 1, 2, and 3 really crack the population in such a way as to give teal a commanding majority in each of their 3 districts. So they get cracked to their advantage, and the blues get packed to their disadvantage. So identifying wasted votes, I have a slide on this. It's a terrible phrase, I have to say, and when I tried this case that's now in the Supreme Court, I really didn't like this phrase, but I was stuck with it because there was a big article that had come out that talked about wasted votes. Wasted votes are the votes in a district that you cast that are 50% and you win. 50% plus 1 vote is a win. So any vote above 50% plus 1 vote is kind of a wasted vote. You could consider it. I would call it an excess vote. Then any district in which you have lost, all the votes you've cast in that district are wasted votes because you lost. So looking back at the example I came up with, you could actually see, you can actually calculate out in each district how many votes are extra or surplus votes that are wasted and how many votes are wasted in lost districts. So in that example where I just gave you, you can see that the lost votes in 4 and 5 are the ones for the teal group. And you can see that for the blue party, look at all the votes that they have wasted. And you see for the teal party, they have only 47 wasted votes total. And the blue party, which got disadvantaged by this gerrymander, has 158, I can't even read. 98, thank you, I don't have my glasses. So to calculate wasted votes, and this comes out of a political science article written by 2 professors after Veith versus Jubilera came out, saying that surplus votes equals the votes cast for the winning party in excess of 50% plus 1, lost votes, the votes cast for the losing party. And you would think that if a plan is fair politically, then there should be a similar number of wasted votes for each party. So they came up with something called the efficiency gap, which measures these wasted votes and compares them against each of the major political parties. They take one group's total lost votes, the other group's total lost votes, they subtract them and divide by the total votes, and they come up with a calculation known as the efficiency gap. How efficient are the votes of each political party placed into the districts? And if the district is 30.2%, which is what the example was I showed you, that's a pretty high efficiency gap in favor of the teal party. What that means is that the teal party is getting 30.2% more seats than you would expect it to get under a neutral or a fair redistricting plan. So they came up with this test for partisan gerrymandering in this law review article, and we decided that it looked like it responded exactly to what Justice Kennedy said in Veith versus Jubilera when he outlined this First Amendment theory he had. He talked about partisan intent, partisan effect, and looking at whether or not it followed the state's usual or traditional way of doing redistricting. We brought a case called Whitford versus Gill. It was filed in 2015 over the Wisconsin General Assembly's map. A 3-judge court was convened. They denied Wisconsin's motion to dismiss the case and try to have a judgment in its favor without a trial. I tried the case in May of 2016, and the court ruled, for the first time in history, that Wisconsin's General Assembly map was a partisan gerrymander and violated the First and 14th Amendment. Now, I say the first case because if we had lost that case, the plaintiffs, we represented Democratic voters who were challenging, in that case, a Republican gerrymander. But I want to underscore that whoever is in power usually does the gerrymandering, so it's not a one-party deal. If we had lost that case, the Supreme Court probably wouldn't have taken it. It would have been just another post-Veith versus Jubilera loss. But because we got the plan declared unconstitutional, in redistricting cases, cases go directly to the Supreme Court. They don't go to the Court of Appeals, and they have to take the case. They have to take it on the merits and rule. And they can either summarily deal with it and say, yeah, we agree, and without an opinion, or they can set it down for oral argument and full briefing, which they did in this case. And my law partner, Paul Smith, at the Campaign Legal Center, it's a nonprofit, nonpartisan organization, we argued the case in the U.S. Supreme Court in October, and we're waiting for a decision. Meanwhile, while we thought the case would be decided by now, we argued it in October, we presume it's been decided and all the opinions have been written. In late 2017, the Supreme Court took another partisan gerrymandering case, this one by Democrats in Maryland involving the congressional seats. So maybe the court is finally thinking that, and by the way, based on the Supreme Court arguments that we held in October, I'm pretty hopeful the Supreme Court is going to come out with a decision before July 1st when they leave for the summer, which declares for the first time that there is a judicially manageable standard for measuring what is one of the biggest stains on our democracy, which is gerrymandering, where politicians take democracy and flip it on its head. And what they do is they cherry pick their voters rather than in a democracy where voters are supposed to choose their elected representatives. So Maryland is being argued in the U.S. Supreme Court tomorrow. I will be there. It's a different kind of a case. It's challenging one district in Maryland that flipped from being a Republican-controlled district to a Democratic voter-controlled district. And the gerrymander was designed to flip that one seat. And we'll see if the Supreme Court does with that case. So that is my presentation. Thank you for listening, and I'll be happy to answer questions as we go along.
I would like to follow up on a few things that you talked about, Jerry. I mean, depending on how the case comes out, and it sounds like you have a prediction or you have an educated guess.
Right. I mean, this is like predicting that you're going to win an Oscar. You know, you really don't want to jinx yourself. So,
Sure.
Based on the oral argument, Justice Kennedy, who is the swing vote, let's face it, in this argument, he asked the most incredibly pointed question of Wisconsin's lawyer in the Supreme Court. And he said, what if the Wisconsin Constitution said that even if Republicans only get 48% of the vote, they're going to be able to get 60% of the seats no matter what? Would that be constitutional? And of course, she hemmed and hawed for a while, and then he said, I'd like an answer to my question. And she said, well, no, that would be unconstitutional. And he said, isn't that what happened here? Wow. So let's hope that, that we're reading the tea leaves right.
So if the court decides that there is a constitutional standard, then what happens?
So then in Wisconsin, of course, the case would go back for a remedy to fix the partisan gerrymander. Normally, legislatures get the first opportunity to redraw the districts. Some would argue that why should a legislature that was elected under an unconstitutional map get any say in how the new map should be drawn, but we'll leave that question for another day. But the one thing it does do is it could set a standard for nationwide other states that could then be sued between now and 2020. And you say, well, the decade's almost over. Why would we do that now? Well, you'd want to invalidate a plan if it's an extreme partisan gerrymander now so that you have a baseline in effect for the post-2020 census when it comes out. So there might be some litigation there. And it would also be a standard that would then apply to the post-2020 redistricting.
So you think it's quite possible that we'll have a flurry of litigation?
It would be light flurries because what we have really tried to show the court, in which we demonstrated, I think, in the oral argument, is this is not going to open the floodgates that all 50 states are going to find themselves sued. The standard we've picked, the efficiency gap, would probably only result in maybe litigation in a dozen states because what we've tried to do is say, we know partisanship is going to be involved in redistricting. It is inherently a political act. You can't pull the politics out of redistricting any more than you can pull the money out of campaign finance reform. So you have to just figure out a way to regulate it and not have the extreme gerrymanders be allowed to continue under the Constitution. So ours really goes to the extremes, the radicals.
So are court decisions the answer here? Doesn't sound that way.
Well, I don't see politicians in states giving up their power to redistrict. Do you? Because the last time I checked, they resist mightily any effort to move their authority from the legislature, say, to an independent commission in some states, which exists.
Yeah. Nathan, I'd like to turn to you to talk a little bit about how this impacts the business community. I mean, this sounds like a conversation about politics and partisanship and the law and the intricacies of court cases, and it is all that, but there is also a real-world impact. Can you address that a little bit?
You know, Jerry said something, and I like to quote from the position paper because it echoes what he says, and I think the language is even stronger. Partisan gerrymandering reverses the normal course of politics by allowing legislators to select their voters rather than the voters selecting their representatives. Partisan gerrymanders achieve their objectives by diluting voter influence and increasing the number of safe seats in elections. So I think there's basically three key points of the impact from a business view and why we all should be interested, why CED would take on this issue. And I really, Mike has been just a great partner in this, and I thank you, Steve, for giving me this opportunity because I've now gotten active about this. So number one is it generates cynicism, and cynicism as a mood of the American people undermines all institutions. So people are obviously distrustful of the Congress, they're distrustful of their government, and I think that bleeds over to distrust of capitalism and the institution of business. And I think that's one thing that we can all recognize, that every one of us in this room has a stake in people embracing their government and people embracing the free market system. Secondly is that as business people, we believe in competition. The great majority of seats in the House of Representatives, most seats in the state legislatures are not competitive. So if we think competition in market produces something good, we probably ought to think that competition in politics produces something good. And then I think in terms of direct impact, Gene, because there's effectively a duopoly, and most gerrymandering, remember, is not just one party dominating another, but deals between legislators of two parties agreeing on preserving their seats. So that reinforces the duopoly. It reinforces the lack of workability because the districts are safe and they're welcome to be extreme in their views. And it promotes crony capitalism because, we didn't say this in the paper, but essentially it creates pay to play in terms of relationships with elected representatives, because the congressman, the state senator, the state legislator knows that she or he is going to return to office next time. And if you want to come and talk to me, did you donate to my campaign? So I think those three areas really are at what's the heart of this political issue for business people.
Yeah. Jane, can you pick up on what Nathan's talking about in terms of the importance of competition in politics?
Yeah, because I think it's completely related to the kinds of themes that he's recognizing. When you look at the competitive elections really are at the heart of our representative democracy. That's the point, is to make them competitive. And right now, as we say in the report, 75% of congressional elections are not competitive. That means that there's a 10% swing. And so when you think about that, you realize that if that's the case, then people who are elected aren't elected as moderates or as people who have to represent an entire constituency. They're beholden only to the people who elected them, who by that kind of majority. And so if that's the case, you end up with increased partisanship, which certainly isn't good for the country or for business, understanding sort of what is happening in this country, and can we get anything done in Congress? And do we have the capacity to compromise? Is there the capacity to actually represent diverse interests? Do you have to take diverse interests into account? And when 75% of these elections are not competitive, you know, it's no wonder that we've got this kind of gridlock. And those 75% represent 85% of voters in this country. So you do end up having a lot of voters whose voices really have become irrelevant in what should be a representative capacity. And you've got gridlock partisanship that just gets entrenched. What you do about that, I think, is, Jerry talks about, the Supreme Court maybe can save us from ourselves. In the report, we recommend that, states really should move to nonpartisan redistricting commissions. There are 4 states that use that approach with good effect. How you actually get people to give up the advantages that they have at this stage with the gerrymandered districts is another question. But I think it's hopefully with some parameters set by the Supreme Court, there can be more incentive or interest in trying to come up with these independent nonpartisan commissions to set districts according to, more neutral standards.
I mean, this is where we're at, right? We understand the legal backdrop of it. We understand a lot of the negative consequences of partisan gerrymandering, and now we want to hear about solutions. Nathan, what do you think of this idea of these nonpartisan or independent panels that doing it? And is this something that the business community could actually rally to support and maybe actually move? I mean, I think you mentioned cynicism earlier. It's hard not to be cynical to think that state legislatures will give up this ability.
Well, Jane just, made the point again, which is, okay, our party is in the minority in the state, population-wise, registration-wise. However, we control both houses of the state legislature. Because we draw the districts for the state legislature, pretty good chance we'll be able to hold on to that power for another 10 years. Why would we want to give that up?
Right.
And what's common, not amongst all four of the states, is that there's an initiative process, and the citizens, through their own ability to write legislation, their own ability to amend their state constitution, took things into their own hands. So I think business has, in states that do have an initiative process, that have a referendum process, I think business, and it's been business leaders, at least in California, who took the lead on redistricting and created our commission. So I think that's for business leaders to step up, and at least in states that have a referendum or initiative process and can amend the laws or the Constitution, for somebody in the business community to take the lead, and then for other business organizations to support that.
There's potential there, you're saying?
There are still states that the people could rewrite the law.
Yeah. Gerry, you have an incredible historic perspective over this issue. I mean, as you look over the arc of history that you've seen with all kinds of voting rights issues, having spent a lot of time at DOJ and prosecuted a lot of cases, what do you see here from a historic perspective? Do you think we're going to come out the other side of this, or do you see it getting worse and worse, or worse before it gets better? Or what do you think of that?
Well, the one thing we told the Supreme Court is that partisan gerrymandering today is worse than it has ever been in the history of the United States. And because of the sophisticated technology that is available, that you can slice and dice voters down to the block level based on partisanship, not just race and ethnicity, but on partisanship, that the Supreme Court, and we actually, my law partner Paul Smith said to the Supreme Court, you're the last institution that can save the democracy from the ill effects of gerrymandering. And he said, if you don't do that, then in the post-2020 redistricting cycle, you will see a festival of gerrymandering like you've never seen before if you don't rein it in. And only rein in the extreme gerrymanders. The Supreme Court likes bright line tests. So we came up with what we think is a pretty good bright line test. You either are below the line or you're above the line. And if you're above the line, you're likely to be sued and have to justify your gerrymander. Going to your point, Nathan, about, and your point too, Jane, about redistricting commissions, there's about 20 states in the United States that have redistricting commissions. I worked on the California Redistricting Commission with Arnold Schwarzenegger to get it passed, and then when we got it passed, we then invited citizens to apply. Yeah. And to show you how interested people are in this issue, 40,000 people applied to be on like the 12-member commission. And we were like, how are we going to get that down to 12? So I said, well, let's give them an essay. That dropped out about 39,000 people. So then we had, we then put in criteria. You couldn't have run for office in the last couple of years. You couldn't have contributed money to a candidate. You couldn't work for an office holder or within the last few years. You couldn't run for office in the next couple of years. And eventually we whittled it down to roughly, I think, 40, as I recall, when I represented.
Then you didn't have enough.
Right. Well, then we had 40 who still wanted to be on the commission, and guess what we did? We did a lottery with balls, where the auditor picked out and said, number 12, Gene Wong, come on down, you're on the commission.
So what happened after this commission? What's happened?
Well, everybody feared that it would be well, they drew districts. They did not get sued, by the way, which is rare in redistricting. And they drew what everybody considers to be a pretty fair map. And so,
Well, there's clear criteria also in California
right,
for
and
the
you have,
drawing.
and that's very important. Adopting criteria by which the districts have to be drawn, and they have to be neutral criteria, fair, traditional redistricting principles. The districts have to be contiguous to each other. You can't have a piece there and a piece there. They have to be relatively compact, and there are measures of compactness. And sometimes you want to preserve the core of existing districts so that the relationship between constituents and office holders gets maintained. And sometimes protecting incumbents can be a traditional redistricting principle because at the congressional level, power is allocated on the Hill based on your seniority. So you don't want to throw somebody out for your state who maybe is the next chairperson of Ways and Means or Rules or one of those vital committees. So, and the one final thing I'll say about these commissions is, in the states that do have commissions, they have come about because of the opportunity for a referendum to be held, because the politicians don't give it up. Right. In some states, like Wisconsin, you can't get anything on the ballot unless the legislature agrees. Same with Virginia, my home state. So it's very difficult to do it there. I think there you need a judicial solution and a standard, and then we can proceed from there.
Jean, can I ask Gerry a question?
Of course.
Okay. Gerry, the two cases in the Supreme Court now, are they on the basis of due process, or are they on the basis of free speech and assembly?
Well, they're both on free speech, and the Wisconsin case also is an equal protection case. That one group is denied the equal protection of the laws under the plan. One involves congressional redistricting, which is Maryland, and the other is the General Assembly in State Assembly in Wisconsin. There is another case that was brought that we tried in last fall in North Carolina, where a 3-judge court in North Carolina ruled that the plan there for congressional districts was unconstitutional, first time in history. And it's great when politicians testify under oath about this stuff, because in North Carolina, which is roughly a 50-50 state, if you look at the 2016 elections, 50% of the people voted for Democrats, 50% of the people voted for Republicans. They have 13 congressional seats in North Carolina. In a 50-50 state, you'd expect there to be 7 one, 6 of the other, 10 Republican districts and 3 Democratic districts. And when we put under oath the people who drew the plan, we said, well, why did you draw a 10-3, not an 11-2? And they said, because we couldn't get to 11-2. We maximized, it's a gift that keeps on giving. So,
wow.
So we'll see. We won that case on using the efficiency gap again. The case was on appeal to the Supreme Court. The Supreme Court stayed the case pending its disposition of Wisconsin and presumably Maryland. So stay tuned on that.
And then how about the Pennsylvania case?
So the Pennsylvania case that recently made the news was a state constitution case decided by the Pennsylvania Supreme Court. The Republicans then had to go into federal court to try to challenge the Pennsylvania map, which is almost impossible to do. First time they tried it, Justice Alito denied it without even referring it to the full court. And then the second time they tried it again, and it was denied again. So that decision is going to stand. And what they did there was they appointed a Stanford law professor to redraw the districts in Pennsylvania, the congressional districts. And he did so, and the court approved them. And they are more compact. They split less counties and cities, and they are more fair in terms of their partisan result. So as you've maybe noted in some Republican incumbents who were advantaged by the gerrymandered map have decided not to run, seeing the writing on the wall, perhaps, that is just going to be a fair plan. So that case is over. There is an effort to impeach the Supreme Court of Pennsylvania, which is underway by some Republican legislators. I don't know that that'll get very far with a Democratic veto, but
now the professor who was appointed to draw the districts, did he have to submit an essay?
No, he did not. He did not. He is actually a pretty noted, he's been hired by several courts, but he is a law professor, so he would be happy to write an essay.
Exactly.
That wouldn't have intimidated him at all, you're right. Jane, I wonder if you could speak a little bit to, if you could sort of chicken and egg for us. There have been several references to how this relates to extremism in politics. I mean, we hear these numbers from Gerry at North Carolina. We're sort of generally aware that no one can agree on anything and there's a lot of gridlock. I mean, is it because of gerrymandering, or is gerrymandering because of division? Like, could you sort that out a little bit?
I think gerrymandering permits it because you end up with results occurring and the real contests become in primaries.
Yeah.
And so if you win a primary, which is, perhaps easier to do because you've got a broader field. And so, if you win a primary, then you're going to win. If you're in the party that is the majority party in that district, then you're going to win the general election. So there's no real competition. So it ends up permitting a partisanship and an extremism that wouldn't result if the general electorate was electing, in a
If the voters were choosing their candidate
instead of
vice
voters were
versa.
choosing their candidate.
Yeah. I think we do have time for a couple of audience questions. Yeah, go ahead in the back. Am I choosing them, Mike? Do I get to choose the people? Yes. Okay, there we go. You.
I served in the Florida legislature, so I've been through this process. Very familiar with what you're saying.
That's Florida.
The point you just made at the end there, the primaries, what happens in terms of the outcome is there's a term primary to the right or primary to the left. So in other words, if you don't vote to the degree that the more right-wing or left-wing side of your party is, then we're going to file someone against you that's even farther off to the extreme. Yeah. So the outcome of that in Congress right now, which I also showed in Congress, is you end up having people on both sides, and it's really creating far less of an interest to come to the middle and find things. Because if you do find that compromise, you get hassle at home. Why did you agree with those nuts? And they end up finding someone to run against you. So that creates voting behavior that unfortunately makes it more difficult to come together. I do want to ask, I think the independent reapportionment, I'm from Florida, but I believe the independent reapportionment idea, and they're a little different, each one of them, is wonderful. But I would also suggest that to the extent that some states don't allow them by petition, I think the business community and a whole lot of other groups in those states that need to put the pressure, build coalitions, and put the pressure on the legislature to do what does not come natural to them, which is to vote against their own interests. But I think the business community has a tremendous amount of power, along with a lot of other maybe non-traditional partners and a lot of other issues, to say this is good for everybody. Good for the
Well,
institution.
and depending what happens in the Supreme Court, I think there may be an opportunity to build some momentum.
That's right.
If the court does provide some standard, and then it becomes less onerous, I think, for these coalitions to actually succeed.
In Florida, actually, I worked on amending the Florida Constitution in the last census period to say that the Florida Constitution should be amended such that the legislature, when it draws districts, can't favor one political party over another or one candidate or incumbent over another. And of course, the Florida legislature then promptly, in addition to challenging the constitutionality of the constitutional provision, which we defended and they lost, then drew the redistricting plan, and we sued them in court, and they lost on the grounds that they had violated the very criteria that they were supposed to adopt. I tell you that these cases are a gift that keeps on giving, because in the Florida case, as you probably well know, the Florida legislature said, well, we didn't draw a plan in favor of one political party over another or any incumbent. We actually got this plan emailed to us from some community college student who said, here's the plan, and we adopted it. So we went to the student and took his deposition, and he said, I don't even know what redistricting is. Wow. And then we found out that it was a political consultant to one of the Florida legislative leaders who had actually hacked the account and sent in the map. Ooh, needless to say,
Wow.
I know. So to your point, though, look, when we pack and crack districts, what we end up with are people on the far left who get packed into sometimes black districts or Hispanic districts or overly Democratic districts. People on the right who want to be safe, with rock-solid Republican districts, and as you say, the middle has shrunk. How many moderate Republicans or Democrats are there in the U.S. Congress right now? A lot fewer today than there were 20, 30 years ago, because most of us, I think, find ourselves in the middle, and yet the middle has almost shrunk to nothing. So that's why we have a lot of deadlock, and that's why, as you correctly point out, people get challenged in primaries, because why did you have a conversation with the other side of the aisle on any issues? When we go to the Hill and we ask Democrats and Republicans, will you co-sponsor this? They say, oh, I love your piece of legislation that would guarantee transparency of the political process and super PAC spending, but I can't put my name on that. I'll get challenged from the right in the primary. And the districts are so rock-solid Republican in their district that they can't do that. The same is true for Democrats. They just can't come together. As a result, I think, of extreme gerrymandering.
These terms packing and cracking suddenly seem appropriately lewd for this conversation. Do we have time for one more question, Mike? No, I think we got to wrap it up. Well, I hope you all agree that we saved the best for last. Thank you, everyone, for a great panel. I enjoyed it.
Thank you.